Hey guys, I have right here in my sweaty little palms the U.S. Court of Appeals for the Sixth Circuit Court, Gun Owners of America against Merrick Garland, the Attorney General of the United States, the Department of Justice, Bureau of Alcohol, Tobacco, Firearms, and Regina Lombardo, the acting director of the ATF. This is in reference to the bump stock ban. Those of you who say bump stocks are stupid, we don't need them, please click off of the video, as this pertains to true Second Amendment supporters only. This is very interesting. Alice Batchelder, circuit judge, said the question before us is whether a bump stock may be properly classified as a machine gun, but this case rests as much on who determines the statute's meaning as does on what the statute means. That's important. I'm going to go over this as plainly as I can because I'm going to have a much better video. I apologize for the poor quality here, but I'm going to have a much better video tomorrow on the meat of this because this is 60 pages long. But I've blitzed through this thing and made all my notes, highlighted everything in here. And I'm no attorney, guys. Those of you that are attorneys, please correct me anything I say wrong. I'm trying to use layman's terms, which is what I operate in, to try to help everybody else understand what's going on as best I can. Again, I'm not pretending to be an attorney, but I can read words. Chevron deference is something that is used in order to give someone, and I'm speaking at a very high level here, they are the true expert in a particular field. So the court system will then take their expert opinion as expert opinion. And that's what they're going to use to determine what a particular law might mean. In other words, this particular topic isn't up for debate, so to speak. It pretty much nixes that potential for debate by saying they're the expert, we're going to go with what they're saying. In this case, with the bump stocks, they were using the Chevron deference to say that, okay, the ATF is making this ruling based on the National Firearms Act, and that the ATF is the one that is responsible for interpreting this law and how it applies to a bump stock because they are the, quote, experts. And Gun Owners of America and their attorneys, which this all came to me from a good friend of mine who is an attorney for Gun Owners of America, works with them. Their argument is that you can't use Chevron deference in criminal law. It can only be used in civil law. The bar for criminal law, because it puts people in jail, it takes their freedom away, the bar for criminal law has to be set way higher, because if the ATF is determining it a certain way, which means it could put people in jail because a criminal offense, there's some very strict criminal penalties that remove a person's freedom. And they're saying that in the civil defense or in civil law, that the bar can be set lower because we're talking about monetary penalties in most cases, not criminal penalties where you're going to jail. Going to jail, again, should require a much higher law. We as Americans should want a much higher bar set to take somebody's freedom away. And they're saying that in this case, Gun Owners of America is saying that you cannot use Chevron deference. It's just not something that you can use because you're giving all the authority, it's an executive branch is what the ATF is. So you're giving the authority to one organization when the legislative branch, which is Congress, should be the ones determining these things, like they did in the GCA, of course, and the NFA. So it's basically saying that you're shifting all of the responsibility to make the law and pursue somebody from a criminal standpoint. You're giving it to the same branch. We have co-equal branches of government for a reason. We have the judicial, executive, and the legislative branches, and they all serve a separate but equal function. The claim is that by giving Chevron deference to the ATF, you were giving legislative and executive power to one entity, and that violates the Separation of Powers Act. I know that I'm not making perfect sense. I will hopefully make better sense whenever I outline all this in my video. It will be a much longer video than this. Those of you that can stomach that, great. Those of you that can't, I apologize. But I wanted to put this out and say that this is a very small but big victory. I know that's pretty contradictory, but it's small in terms of bump stocks, according to this, are still outlawed in all the other circuits. But in the Sixth Circuit, there's the potential that bump stocks will be legalized again based on the Sixth Circuit ruling here. Unfortunately, this doesn't make bump stocks legal across the country, but it does in fact start that domino. That's that first domino that's falling. So this is a big deal in my opinion.